All right, well, hello, everyone. Thank you for coming to today's panel on the expansion of police surveillance. My name is Veronica Hutchison. I'm the managing symposium editor for the Journal of Law Reform here at Michigan. And today we have some incredible speakers and also an incredible moderator, Professor Eve Primus. So with that, I'll let her take it away. I just really want to say thank you to everyone for coming today and for listening to this incredibly important topic.
Hi, so thanks, Veronica, and to all of the students who have worked so hard to organize this. I want to take a minute to welcome the panelists. You have a very distinguished group of individuals to talk to you today about the expansion of police surveillance technology. So the way this is going to work is I'm going to do a very brief introduction of the four of them, and then kick it off with a question that each one of them will answer, and then we'll have a dialogue about the ways in which police surveillance technology has expanded or not, and the consequences, both intended and unintended, of technology-driven proposed reforms of the criminal system. So with us here today, we have the pleasure of having Catherine Crump, who is the director of the Samuelson Law, Technology, and Public Policy Clinic at UC Berkeley School of Law. Her advocacy focuses on protecting privacy and free speech and ensuring that new technologies are integrated into the criminal legal system with attention to equity and accuracy. Also joining us is Professor Elizabeth Joh. She is the Martin Luther King Jr., very timely title to her Professor of Law chair at the University of California, Davis School of Law, where she teaches criminal law and procedure, constitutional law, and policing. Professor Joh's research focuses on the intersection of technological innovation and police practices, and she has written widely about emerging technologies, surveillance, and policing practices. Also joining us today is Nathan Freed Wessler. He is a deputy director of the National ACLU's Speech, Privacy, and Technology Project, where he focuses on litigation and advocacy around surveillance and privacy issues, including government searches of electronic devices, requests for sensitive data held by third parties, and the use of surveillance technologies. And last but certainly not least, we are very excited to have Emily Tucker here. She is the executive director at the Center on Privacy and Technology at Georgetown Law, where she also teaches courses on surveillance and civil rights. The center conducts research and engages in advocacy to expose and mitigate the impact of surveillance on historically marginalized communities. So with those brief introductions, what I'm going to do is pose the following question to all four of our panelists, and they will each take about 5 minutes to answer this question and situate it in light of what they themselves work on and study. So the question is, how, in your view, has police surveillance adapted in America in recent years or changed? And how does your work examine these kinds of changes? So let's start with Catherine Crump.
Thanks so much. Thanks to all of you for having me. I'm excited to be here today. So just to zoom out and talk about the big picture, I think police surveillance has changed substantially over the last 20 years. There's just been a rise in sort of cheap, ubiquitous digital technologies coupled with increasingly affordable digital storage. And the consequence of that is that there's an array of surveillance technologies available to police that simply weren't present 20 years ago. Digital surveillance cameras that are increasingly networked together and analyzable through AI, automatic license plate readers that can record the plate of every passing car and automatically check to see whether they're perhaps associated with someone wanted of a felony arrest warrant. Government can obtain cell phone records from mobile phone companies to track people historically or in real time. And this is in some sense new in the last 20 years. So to be sure, right, previously, major federal law enforcement agencies, the CIA, or intelligence agencies like the CIA, the FBI, did have sophisticated technologies. And advocacy organizations such as the ACLU or Nate Works, focus energies there. But sort of realized in the early 21st century that increasingly sophisticated surveillance technologies became more prevalent in local police departments and for private citizens too, right? Think about smartphones and the extent to which we video ourselves and each other all the time and upload it to social media. And this technologies were available to local law enforcement agencies. And I would say we've been grappling with the consequences of that ever since. sense. So one big consequence, especially initially, was that a lot of the use of this technology was largely unregulated. So the FBI, for example, has lawyers who vet its use of technology. One may or may not agree with their assessments of what can or should be used, but there was sort of a process for it, right? In contrast, the average local police department has something like 10 agents, and this technology sort of went out into the world in a much less regulated way. So one of the big questions, I think, to the extent we believe, and I think most of us do, that this technology should be regulated, is who should do that, right? So most people think, law enforcement is an agency whose primary objective is furthering public safety, and it's hard for sort of single mission agencies like that to focus on other concerns, right? And surveillance technology involves trade-offs between privacy, free speech, if you think about it in the context of being used on political protesters, particularly Black Lives Matter in the past few years. And presumably we want some kind of political input into that, as well as maybe some kind of constitutional analysis. So I think the question really has been, who is going to jump into this void and help exercise some regulation? So one option is courts. And I'm assuming Nate, who argued the Carpenter historical cell phone tracking case in the Supreme Court, will talk about that more extensively. So one thing I just want to point out about that is, interestingly, about 10 years ago, Justice Sotomayor said, oh, we're about to enter a day of full employment for digital surveillance lawyers in the Supreme Court. There's just going to be a lot of cases on this, was the prediction. But actually, at least so far, that hasn't happened in the Supreme Court. There have been 2 or 3 major cases in the last few years: the Carpenter case that Nate argued, the Riley case, which dealt with searches of cell phones incident to arrest, and maybe the Jones case, which dealt with attachment of a GPS device to a car to track its location. But in general, there's just a ton of unanswered questions. The courts move very slowly. And in the meantime, a lot of this technology has become integrated into departments without much constitutional review. Congress hasn't passed meaningful digital surveillance legislation really since 1986, right? Before the World Wide Web was invented. There have been little things, but there hasn't been a broad overhaul. Some states have jumped into the void, but they've tended to pass regulation that deals with like one piece of technology at a time, right? So several states, for example, have laws regulating automated license plate readers, but maybe not, some other piece of technology. There's also been an interesting movement of regulation at the municipal level. So the ACLU has a campaign called CCOPS, Community Control Over Police Surveillance, and so do a lot of grassroots organizations. And the intuition here is that local police departments shouldn't make these decisions on their own. Local elected officials should be involved. About 16 municipalities across 8 states have passed laws regulating police use of surveillance technology, generally speaking, saying that if a police department wants to use a piece of surveillance technology, they need to first go to the city council or some other body to get approval. The students in my clinic, I teach a technology law and policy clinic at Berkeley Law School, wrote a report analyzing the 16 current ordinances out there and sort of summarizing what's in them. The advantage of this, right, is that you can take into account local circumstances, right? A municipality like Oakland, near where I live, might really want robust privacy protections and be very sensitive to racial justice issues. Someplace else might have a different view, and you can sort of tailor those ordinances to local conditions. So another thing my clinic did is we actually wrote a privacy policy for the city of Oakland, a values statement the city can use when trying to decide whether to adopt surveillance technology. The disadvantage is this campaign has been going on for something like, I don't know, at least 5 years, probably longer, and only 16 municipalities have passed these laws, right? Which is not much, and is clearly not scaling as fast as other people would have liked. There are other interesting regulatory models out there too. There's an organization at NYU called the Policing Project, which has actually worked with technology vendors to assess their surveillance technology and suggest improvements of various types. I find this model, this is a very controversial model, right? Some people think, oh, this organization is just sold out, right? They take money from the vendors, they evaluate the technology, and they suggest, at most marginal improvements. Other people think, wow, actually, if you can get, say, say a company that sells body cameras to make even a marginal improvement, right? That improvement automatically rolls out across all police departments rather than just in one city. So I think a lot of different approaches are going on right now, trying to bring some democratic control over surveillance technology. I just want to point out two additional quick developments, which I think are quite important and shape the debate, and then I'll pass it on to someone else. One is the rise of private surveillance technology, in particular smartphones. So one of the things my clinic is currently doing is we pulled all of the warrants issued in the wake of the George Floyd murder and have been systematically analyzing them. And the technologies you see in that are not technologies controlled by police departments, right? The typical fact pattern is people film themselves committing arson, right? Or engaged in protests, and either they or their friends upload it. And so police departments just search social media to obtain the footage people themselves took to draw connections between people on these social networks, right? Since we all identify who our friends are. And then obtaining cell phone location data to verify who is in particular places. And so I think that's something that's going to be really tricky to deal with, right? If we're all videotaping ourselves all the times, doing whatever we do, and then making that available, no matter, that's just a harder regulatory problem. The other issue I've been thinking a fair amount about is the sort of obscure world of data sharing, right? So if you're in Oakland and you don't like what the Oakland Police Department is doing when it comes to surveillance, you can go to the Oakland City Council. But there's also something here. There's a Bay Area Regional Fusion Center, right, which is fully funded by the federal government, but technically state controlled, and these are all over the country, right? If you don't like what they're doing, it's very hard to know who you complain to or how you have an impact. And I think this has huge implications for democratic control of policing. So just one quick example, in California, California passed a law prohibiting law enforcement agencies from actively helping immigration removal authorities. And, I think the intent behind that was to make sure that California police departments weren't helping people be detained and arrested and removed for immigration offenses. But it didn't attend to data sharing. So the typical fact pattern is a local police department, for example, in a very progressive part of the country, uploads all of its automatic license plate readers to a regional sharing database. And it just isn't conscious of the fact that ICE has access to the same database, and then that very data is used to help find people. So I think this sharing infrastructure is another thing we need to do more work around than we have so far. So I guess I'll stop there and turn it over to whoever's next.
All right, Professor Elizabeth Joe.
Great. Thank you so much for inviting me to this panel among these distinguished guests. It's a really important topic, and I'm happy to be talking about it. Just like Professor Crump, I am going to give you a little bit of a broad overview of what some of the issues are and what has happened with police and technology in a slightly different sense. So let's think about how police technology has evolved since the 2010s. So in the 2010s, you start to see a lot of announcements, piloting, reporting on all of these tech tools. So for example, Santa Cruz, California becomes one of the first police departments to use a predictive policing tool to figure out where in the future there may be a place for police to draw their attention within the physical city. Rialto, California becomes one of the first American police departments to pilot a body camera project, right? That seems sort of quaint now, they're ubiquitous, but that's not so long ago. Right around the same time, the Chicago Police Department starts to pilot a project about using an algorithmic risk assessment tool to try and determine who might be at risk of being a perpetrator or a victim of gun violence. So you might call that first part, the 2010s, where police are starting to use a lot more of these technologies, kind of a first wave of AI in policing. First wave because it's seen as a kind of, unqualified gee whiz big tech tool, so much so that in 2011, Time magazine called predictive policing one of the best inventions of the year. The real sort of a rosy-hued view of how these would be used. So in the ensuing years, what have we learned, right? So to draw on the work and of many others in this area, we have a number of questions. So I'll just point out a few of them. One, questions about the data. How is that data created? Who decides what happens to that data? What isn't included? What will happen to it? Whether there are issues with that data, et cetera. Second, relevant particularly here, issues of bias and especially racial bias that may be altering our perceptions of both the data, even the very questions about where some of these big technology tools we used. Third, questions about transparency and accountability. Everything ranging from how does a community even find out that their own police department is going to be using some of these tools, to things of larger questions about how will local communities know about the efficacy of these programs, whether there are better alternatives, whether some of these programs should be used at all. Fourth, an attention to the fact that a lot of these tools, in fact, most of them, when we think about the hardware or software, whether we mean the body cameras, the data storage systems, the software for prediction, even the most mundane aspects of policing are now increasingly being developed and sold or licensed or contracted out by private companies. So that's important because here, police departments are customers for vendors of police technologies, right? So Professor Crump has referred to this, but that's, I really want to foreground that. It's not that the police are somehow developing these tools for themselves. They're really in a customer-vendor relationship. And that's been incredibly important for transparency and accountability, as well as a whole host of other questions, because very often the police themselves may not know exactly how to explain what's going on for a variety of reasons. Another thing I would add here is that this is an old question in policing, but I think highlighted today. And that is, I think that the private-public dimension with technology is becoming more and more complicated, and that line is kind of disappearing altogether. So when we think about the police using technological tools, it's not only the tools that they use themselves directly, but increasingly because of things like the Internet of Things, because of the fact that even local neighborhoods, neighbors can band together and buy their own license plate reader systems. They can turn over footage from their own cameras. You know, this kind of traditional line we've had between public and private is largely, it's really hard to even make that line at all. And more recently, I've talked about the emergence of what you might call a gig surveillance economy. And the idea here is that, as Professor Crump has mentioned, these tools are really cheap to use and they don't require any expertise at all. So we're very quickly coming upon a scenario in which you could imagine ordinary folks, just like they do other kinds of gig work, collect surveillance for any kind of bid, right? I mean, everybody can wear a camera, everybody can put a license plate reader on their cars. And I think these tools, because their increasing sophistication and their cheapness are just a kind of inevitability, I think there are some really big questions about what that means that are not exactly how we think of traditional policing. So where are we today at the beginning of 2022? I think that these trends are accelerating in terms of how widespread these technological tools are being used among law enforcement agencies, but we also see an intensification of criticism. So you might say that we're in a kind of second wave of the use of technological tools by the police. So for example, Santa Cruz, the example I began with, they were one of the first to adopt predictive policing programs. And now they have most recently became one of the first major American cities to say, hey, we're going to ban predictive policing because we realize there are all these kinds of problems with it. We see tech-specific bans or proposals for bans, most notably when it comes to things like facial recognition. And then we see, and this is a positive development, a vocabulary in which people are talking about whether it's algorithmic accountability or fairness and transparency in algorithms and artificial intelligence. All of these things are good because they are moves for oversight. But I think it's fair to say that I think the context is quite complicated in the United States, particularly when we don't have a general national data protection law, anything of that sort, and we're really relying on locales to kind of sort things out for themselves.
All right, wonderful. Okay, Nate Wessler, I will put the same question over to you about how the emerging technologies have adapted and changed and how your work has intersected with that.
Sure. Thanks. I'm really thrilled to be here. So I appreciate the invitation and really honored to be with this really fantastic group. Look forward to the discussion. So I'll cover some of the same themes that Professors Crump and Joe did, but maybe try to frame them a little differently, and then talk about what that work looks like a little bit in the courts and how I approach it in my work. So at some level, these questions about how the law should regulate police use of surveillance technologies are not new, right? The Supreme Court many decades ago, getting close to a century ago, in the Olmstead case, tried to address wiretapping, and it took it, I think, about 60 years to, or 40 years rather, to get from a bad rule saying no warrant required to a better rule saying at least this needs to be regulated by a strong warrant regime. But in the last couple decades, advances in technology have just taken off in a way that have allowed law enforcement to both gather and analyze just orders of magnitude more information more quickly, with less effort, at much lower cost. And so the kind of scale of the problem is really unprecedented, even though the basic tension of how we should control law enforcement access to some of the most sensitive pieces of information about us isn't itself new. So I think about the kinds of technologies out there in a few buckets. So there are certainly surveillance technologies operated by law enforcement itself. Face recognition technology is something I've been focusing on increasingly in the last 2 or 3 years. And it's technology that we at the ACLU are particularly concerned about, both because of its potential to allow pervasive population-wide surveillance that can, if it was to be used on a network of surveillance cameras, could allow the government to identify everyone or anyone at a particular place, or to track people across space and time as they move about their lives, and to do it instantaneously through machine learning algorithms. But it's also a disturbing technology because it doesn't work as advertised a lot of the time. It has failure rates. Those failure rates are particularly worse for darker skinned people, for women, for younger and older people. And so communities of color in particular that are already over-policed are now facing the prospect, and in fact the reality, of failed false identifications by this flawed technology that can lead to really consequential results, such as false arrests. And I'm a part of a team along with students in Professor Steinberg's Civil Rights Litigation Initiative at the University of Michigan, suing the Detroit Police Department on behalf of one man, Robert Williams, who was falsely arrested as a result of this technology. But other technologies like automated license plate readers that allow creation of these massive databases tracking where people have traveled over time, pole cameras that can be affixed to a utility pole and watch somebody's house for months at a time with an unblinking eye, and then use machine learning video analytics to quickly, instantaneously search through that footage to look for events like somebody coming or going, or somebody holding a particular item. And forensic extraction devices that allow law enforcement to download the entire contents of somebody's smartphone or laptop and to search it virtually instantaneously to identify basically anything they want, including stuff that people don't actually know is saved there, metadata and deleted items. Tremendously powerful. So those are surveillance technologies that police deploy themselves. Then, of course, there's the whole universe of sensitive data about us held by companies we interact with. And this is really where the third-party doctrine comes in, something I've done a lot of work litigating, where we have everything from location data held by our cell phone companies, that was the subject of the Supreme Court's decision in Carpenter requiring a warrant, to other kinds of location data. Google sits on this huge database, they call it their sensor vault, with GPS and other location data from smartphone users, iPhone users as well, who run a Google app, or Android users who are using Google's own system. And they can search it in various ways, including to identify every person within a particular geographic area at a particular time. Tremendously powerful. Of course, there's lots of content of our communications, emails and text messages, cloud stored accounts. And there's the whole world of these so-called smart devices, right? Wearables, right? Smart watches, so-called, and all of the growing number of internet-connected devices in our homes that are doing data gathering and then sending it to a cloud server somewhere that's doing data analytics, and companies are selling it to make our lives more fun and more interesting and more convenient. But of course, that's a lot of sensitive data now sitting there for police potentially. And then there's the problem of the confluence of law enforcement trying to get access to data somebody else gathered, but not trying to compel them to turn it over with a subpoena or a warrant, but rather just becoming a consumer of that data. And so we are litigating right now a Freedom of Information Act case against the Department of Homeland Security and CBP and ICE, trying to get records about their purchase of cell phone location data derived from apps on our phones. So the problem here is that there's this huge gray market where apps on our phones gather location information, often for no good reason related to the operation of the app, but rather to monetize it and sell it to advertising networks, insurers, anyone else out there who wants to buy from data brokers. And law enforcement agencies, certainly at the federal level and increasingly at the state and local level, are realizing they can just go to a contractor and buy that same data and just do a total sidestep around the warrant requirement that the Supreme Court has imposed when they try to force access to it, compel access. And it's a very serious problem because this information is every bit as sensitive and revealing as the kind of location information that cell phone companies are sitting on themselves. And in fact, sometimes more revealing because GPS data is often more precise than the cell tower information out there. So just in my last minute, just talk a little bit about sort of how I think, in terms of our litigation work, about these issues. And in some way, I see my and my colleagues' job as trying to help courts understand which older Fourth Amendment doctrines might have made sense in pre-digital contexts. We often disagree with them in those contexts, but maybe there was some basis, but that cannot be applied in the same way in the digital world. So the third-party doctrine that was an issue in the Carpenter case is a good example. We have not sought to get courts to overturn the 1970s cases about bank records or dial telephone numbers, but rather to explain why somebody's cell phone location history is just categorically more sensitive and more in need of protection. Other doctrines that we've done a lot of thinking and work on are the border search doctrine, trying to get a warrant requirement or at least a individualized suspicion, reasonable suspicion requirement before border authorities can search somebody's smartphone. The public exposure doctrine, right? When it comes to a poll cam surveillance of someone's home, right? The kind of classic Fourth Amendment rule is, if you expose something to public view, you can't complain if police are the ones looking at it instead of some passing member of the public. But we think that can't be the rule when you're talking about a police surveillance device that is gathering 8 months worth of every single coming and going at your front door. That has to require greater protection. Or the abandonment doctrine. So under the Fourth Amendment, generally, if you have abandoned an item, then you are deemed to have given up your Fourth Amendment interest in it. And if police obtain it without a warrant, too bad for you. We've been filing amicus briefs in criminal cases around the country involving what we call unavoidably shed DNA. This is where police have a suspect. They want to see if that suspect's DNA matches some crime scene sample. And so they send out a plainclothes cop to follow that person around. And when they throw out a cigarette butt or put down a coffee cup at a Starbucks or discard any other item they've touched, police quietly bag it and send it off to the forensics lab and sequence the DNA without a warrant on the theory that you abandoned that item. And we've been arguing that, sure, maybe you abandoned your coffee cup, but you can't be deemed to have abandoned your Fourth Amendment privacy interest in the DNA because there's no voluntariness really with which you shed DNA. We can't avoid DNA getting onto everything we touch, and the sensitivity of that information to potentially reveal medical proclivities, family history, ancestry, and more is just out of all proportion to the privacy interest in physical items that traditionally the abandonment doctrine has applied to. So there's lots more I could say about how we're approaching these issues around the transparency side, legislatively, and various litigation strategies, but I think I'll stop there and look forward to discussing more.
Okay, great. And Emily Tucker, why don't you join in and tell us why things might not have changed as much as other people think?
Thank you so much, Eve, and thank you to the symposium organizers for including me in this really interesting conversation and really important conference. So I work at the Center on Privacy and Technology at Georgetown, and our whole reason for being is to expose and mitigate the impact of tech-enhanced surveillance on historically marginalized communities. That's our mission statement. And in pursuing that mission, we've written 4 reports on law enforcement use of face recognition. We're about to release the findings of almost 3 years of research on the surveillance capabilities and practices of federal immigration authorities. We also do research and advocacy in the areas of commercial data practices and worker surveillance. And because of the work that we do, we regularly find ourselves in conversations either with other advocates, with grassroots groups, or with elected officials about what the right policy response is to whatever the latest surveillance technology controversy is. And one of the tensions that inevitably frames those conversations is, can the tech in question, whether through technical changes or regulatory changes, be made good? Can it be put to uses that are good or not? And while at the center, I admit we usually find ourselves answering that question in the negative, in context outside of law enforcement, I do think it can be a worthwhile inquiry. If you talk to workers, for example, who are trying to do gig economy organizing, they see some ways that some of the technologies that are currently being used in extractive and exploitative ways, some ways that those technologies could be reformed, revised, or regulated to benefit labor. But in the policing context, the answer to the question of whether the technology is under scrutiny in our panel today, primarily algorithms that work on massive data sets, whether those technologies can ever help to produce justice in the context of policing, the answer to that always has to be no. It has to be no, even if we solve the problem of quote unquote dirty data in predictive policing software, even if face recognition achieves near perfect accuracy across demographic categories. And even if we one day repair the systemic inequities underlying policing so that we live not in a utopia, but in an imaginably good society of the kind we can and must hope to create. Even in that world, I want to say, a policing algorithm can never be an instrument for justice. And I want to talk about why. The reason for this really has nothing to do with technology, actually. An algorithm is just any calculative procedure that can be followed without insight. Humans use algorithmic thinking whenever we follow a dinner recipe or figure out the quickest route to work. There's nothing inherently wrong with algorithmic processing. What is wrong is to use algorithmic processing in spaces where what is needed is not automatic calculation, but ethical deliberation. The way that any algorithm functions is by holding constant a set of definitions and value assignments. In policing algorithms, those definitions relate to crime, quote unquote crime. Not only what kind of conduct is criminal, but what kind of crime should be policed and what the boundaries of the criminal category should be generally. When we encode those definitions in an algorithm, we're making them static. We're removing them from the space of political contestation and setting them up as facts that delimit the activities of consciousness in that space. Quote unquote criminality is then treated not as a concept that societies create and invoke in countless ever-changing ways, but as a thing that exists in the world and need only be identified and removed. An inspector general audit of one of LAPD's predictive policing programs known as LASER described the program like this. The basic premise, this is a quote, the basic premise is to target with laser-like precision the violent repeat offenders and gang members who commit crimes in the specific target areas. The program is analogous to laser surgery, where a trained medical doctor uses modern technology to remove tumors or improve eyesight. But crime is not cancer or poor eyesight. Crime is a label that some societies assign through more and less democratic processes to some kinds of conduct to justify other kinds of conduct. Its definitions always say at least as much about the power arrangements in the particular society as they do about the nature of the labeled conduct. This is not to say that transgression isn't real, that individual and community harm is not real, or that redress in cases of transgression and harm is not important. Actually, it's to say the opposite, that those things are so deeply real and important that they cannot be approached algorithmically, that to approach them algorithmically will always do violence. I find it really interesting and really telling, actually, how hard it is for us to intuitively feel algorithms as inherently wrong in the policing context, as opposed to other parts of the criminal legal system where they're also common, like sentencing, for example, where the outcry against that practice has been almost unanimous, at least on the kind of democratic liberal side of things. And I think it's because policing is the arena in which people most unquestioningly experience themselves and others as objects of rather than participants in supposedly democratic policy implementation. In adjudicative and legislative contexts, there's still a sort of justice pretense. Judges have to explicitly take up questions of guilt and innocence, of degrees of harm and of appropriate response to harm. Legislators have to explicitly take up questions of what communities need and want. The way they take up those questions may be fatally trivial, and our expectations of them as the liberators about those questions may also be fatally trivial. But we still talk about the failures of those institutions in terms of our hope to realize human goods within them. When it comes to policing, though, we seem to have lost any sense of justice as something that cannot be systematized, as something we must always be working out together in the spaces where we live, through the things that we do and the things that happen to us. It's hard for us to see that algorithms should never drive decisions about how policing is done or who is subject to it, because when it comes to policing, we in some sense already see ourselves as data. So I don't know if this is really an answer to the question that we were asked, but I think what I'm trying to say is that this algorithmic conception of policing is extraordinarily harmful. It underlies all of these technologies, and while the problems that tech like face recognition or predictive policing algorithms expose are not new, they are a drastic escalation. And I also think they are an opportunity, especially in the political moment that has emerged in the last few years, where suddenly abolition has become a hashtag. There is an opportunity to notice something about what these technologies, to notice that these technologies show us something about what the sort of fundamental flaw is in our way of thinking about policing in the United States.
Okay, great. Thank you so much to all four of you for that very in-depth introduction to some of the issues that the law is grappling with related to the expansion in police surveillance technology. I sort of, as I heard all of you speak, I hear sort of two different buckets, right? There's the idea of how is it that police surveillance has grown the way that it has. And as Nate Wessler said, like it's become cheaper and more readily available. I think Professor Joe said this also, as did, many of our other panelists. And so that explains like why police departments are getting increased access to it. It provides them with a lot of information relatively quickly and cheaply. But also there's, within that, like, what's the problem with it? What is the need for regulation? And so I've heard, first, Emily Tucker saying like, look, these are supposed to be ethical, deliberative processes to determine who you want to arrest or charge with a crime. And we're now using algorithmic processing instead of that, which is never the right way to approach it and is inherently harmful. And Nate Wessler saying these technologies are often wrong, right? They're identifying the wrong people. And I also heard, multiple panelists talk about the ways in which these technologies might be biased. And so I want to actually, just to start, hit a little bit more on that, because it's something I think a lot of students hear, but don't necessarily understand exactly what it means to say the technology is biased against certain communities of color or people who are women or people who are older, et cetera. So Professor Joe, since you brought up the issue of bias, could you talk for a moment just about the problematic ways in which a lot of police surveillance technology either get it wrong because of biases in the creation, or even if they don't get it wrong, are used disproportionately in harmful ways?
Sure. I mean, I think my co-panelists will have a lot to say about this as well, but, we can think of, we can put it in different categories. Some are the bias that lead to individual mistakes. So if we know, for example, that a facial recognition program inaccurately identifies people of color, and particularly women in these communities, or non-binary or transgender persons, that means that your risk of being identified inaccurately, it kind of depends on who you are. And that shouldn't be the case, right? I mean, that just seems intuitively unfair. But if we know that this is often a kind of first cut about how police might try to identify a suspect in a past offense, then some people will bear the risk of a mistaken offense much more than others. And these are quite literal harms in the sense that you may be stopped, you may be arrested wrongfully. So that there's the issue of bias in the individual case. When it comes to bias on a much broader abstract level, we might also say that, well, why is it that we have decided that certain kinds of data are going to be used for certain kinds of offenses in, let's say, a predictive software program? Why one community in the city versus another community in the city? Why do they bear the brunt of this particular kind of experiment? And we really should call it out for what it is. Very often, even though we're now kind of well into more than a decade of these kinds of programs, they still evolve in lots of different ways. And let's face it, they're often pilots, they're experiments on particular communities and not others. You know, there are lots of communities in the United States that have never experienced a predictive policing program. But on the other hand, there are many communities that have experienced many different kinds of policing interventions in the forms of pilots or experiments, of which big tech is just only one of them, right? So there's bias in that kind of global sense as well. And then one of the things for law students I think is really challenging to think about is we often, and of course, you, Professor Primus, are a professor of criminal procedure, right? So we like the core of this is thinking about, well, criminal defendants are often kind of standing in for all of us in terms of determining our rights. And I think one of the biggest problems with these surveillance programs or big data programs is some of them surely become contested in individual cases, but very often they don't really get to the level of contestability. They may just be a first cut that law enforcement uses to try and narrow down a group of people or a set of suspects. They have harms and biases because they lead to harassment short of arrest, or they lead to increased surveillance versus no surveillance at all. And that is extremely challenging to address in an individual case because it may never come to that individual case. And I think that is really hard in the traditional way we think about criminal procedure, criminal cases, and individual cases as a way of defining broadly all of our rights.
Yeah, that's very interesting. Thank you so much. You know, if you agree that there is a need for regulation here, Professor Crump raised the institutional competence question, right, of where should the regulation take place? And so I'm going to ask Nate Wessler, since you've been doing so much in the litigation sphere, to talk a little bit about whether you think courts are the right place to pursue regulation of emerging technologies that police are using, and how good are judges at both understanding this technology and using the Fourth Amendment or state laws to restrict police practices when the technology gets too large?
Yeah, so, you know, I'm a litigator. I certainly think courts are an important place to be trying to address these issues, but by no means are courts the end all be all. And sometimes they just can't be effective. Sometimes they can, but only years too late, right? So, you know, part of the problem is the speed of technology change and the speed of police adoption of technology compared to the speed of litigation. You know, cases just take a long time. That long time is compounded by problems of police secrecy, right? So we've seen over and over again, police adoption of surveillance technologies or access to sensitive digital data, coupled with deliberate attempts to hide that from the public, from criminal defendants and their attorneys, and even from courts. So we saw that, for example, you know, famously with cell site simulator technology. These are devices that police use to mimic cell towers and send out signals that force all the phones in the area to report back and say, oh, here I am. This is my unique identifying serial number. And then police can track a particular phone. They can get a list of all the phones in an area, identify people and locate them inside of homes and other constitutionally protected spaces. And for years, not only were the federal agencies using this and not informing magistrate judges of what they were doing when they were going to get judicial authorization for surveillance, but they also were forcing state and local police departments to sign strict non-disclosure agreements that prohibited those agencies from disclosing even the fact that they'd used this technology, much less its capabilities, to defense attorneys, to the public, and even to judges in warrant applications, in court hearings. And so it was years until courts and advocates, civil liberties, privacy advocates, started to learn what was going on. And we see similar dynamics around face recognition technology. So the claim at the core of our litigation on behalf of Mr. Williams out of the Detroit area is that the arresting officer, after using face recognition technology that incorrectly identified Mr. Williams as a shoplifting perpetrator, hid material information from the magistrate judge in the warrant affidavit for the arrest warrant by not informing the judge that this technology has error rates. Those error rates are particularly bad for people of color. That in fact, the sheet that came back from the face recognition system from the examiner said in it, this is not, in bright red capital letters, this face recognition match should only be used as a tip. It's not probable cause. But they, with only one other really insufficient, supposedly confirmatory step, they basically relied on it as probable cause. And so the judge was sort of none the wiser that the flaws in this should affect the probable cause determination. So we see that over and over. Sometimes courts can eventually get there. The court got there, Supreme Court in the Carpenter case, but it answered one little question while trying to set some parameters for the bigger question about the third party doctrine, and that still has to be litigated. And then the last thing I'll say about the courts is that a lot of this litigation ends up being about whether a warrant is required or not. And that's an important protection. So, there's a reason that it's spelled out in the Constitution, probable cause and an independent magistrate, that really matters. But it doesn't matter sometimes as much as we'd want it to. And it's very hard to get courts to say, actually, this whole technology, this whole technique is off limits. Sometimes it's possible. And our litigation in Baltimore, resulting in a really amazing Fourth Circuit en banc decision saying that an aerial surveillance program that uses these gigapixel wide angle surveillance cameras on airplanes to see the entire city of Baltimore effectively, and be able to track people and cars all through it, that just per se violates the Fourth Amendment because it's a dragnet search. That's relatively rare though, and there are some technologies that just shouldn't be on the table for police, and often that's going to have to be done through legislative bodies.
Thank you. Professor Crump, I may turn to you, as Nate Wessler has told us, it's slow in the courts. Sometimes they won't issue broad policies because they're dealing with one case at a time, and they're limited by the record that is presented to them and whatever is hidden from that record. So I know you've done work, as you've described, trying to get either regulatory bodies or legislative bodies to take action to protect privacy and limit police surveillance. I wonder if you could speak about what you envision to be the pros or cons of adopting a non-judicial based approach to limiting police use of this technology.
Thanks for the question. I mean, in general, I think a legislative solution is preferable, in part because I think it will be seen to have more legitimacy overall. Though courts are slow moving, I do think when courts weigh in, it then can reinforce legislative efforts by setting some floors beyond which we cannot sink. The problem is that, and this isn't a problem with surveillance technology specifically, it's a more global problem. It is difficult to get Congress to act. And given the national scope of many of the technology vendors and systems, congressional action just seems very important addressing some of these challenges. I mean, the other thing that's been happening that's a little hopeful is actually the California state legislature has been particularly active on privacy concerns. For example, passing a law requiring more protections than federal law for certain types of cell phone data. And because many of the tech companies are based in California, that can have broader ramifications. So I think there are many advantages to legislative solution, but unfortunately, I think the scene at Congress right now is as bleak on this as in many other pressing problems that we're currently facing.
And Emily Tucker, you mentioned your center is publishing all of these reports detailing the problems with the use of certain kinds of technology. What is the advocacy that you hope to use those reports to achieve? Like how are you going about trying to tackle regulating or limiting police use of surveillance technologies?
So I think the biggest thing that we're trying to do is support organizing. I think that one of the big problems is that that the digital infrastructure that's enabling all of this surveillance, that the contracts that put the hardware in place, all of this happened without any kind of public participation, without any kind of community involvement or oversight, and without the chance for communities that have been organizing against mass incarceration for decades now to to intervene in the political process. And so we're really trying to do research and advocacy in a way to make it more possible for the people who are most impacted by the surveillance to participate in the political process. And one thing I'm really concerned about when it comes to efforts to regulate and rein in this tech, especially at the state and local level, is the push towards these so-called transparency or accountability bills, which have become quite popular. I think when it comes to carceral technology, it's really important that we not enact so-called reforms that build carceral bureaucracy. So, all of these bills that call for public hearings and regular reporting and establishment of community advisory boards, you always have to ask when on the surface, these look like mechanisms for accountability, right? But when it comes to carceral systems, you have to ask yourself about any proposed reform. How does this proposal vest power? How does it vest resources? In the case of a lot of these bills, the answer is it vests power and resources in the police. The police are the ones with the control over the initial disclosures about the technologies. And then those disclosures are the things that frame the public hearings. They are the ones that have control over the hearing processes. The police write their own annual reports, are in charge of the public engagement process. So I just think we actually need to do something which people in power will tell us is impossible, which is undo this. We need to stop collecting massive amounts of data. We need to stop linking the data sets that we have to one another, and we need to simply prohibit a lot of these surveillance practices.
Okay, I want to tell you that the chat is open for you. The question and answer is open for your questions. I think Professor Joe wants to jump in as part of the conversation here, and feel free to type your questions if you have them.
Yeah, thanks. I just want to add one thought after these wonderful comments from the panelists. I also think, speaking to the lost in audience here, I think if you've shown up here today, it's in large in part because you're curious or you care a lot about these issues in policing and criminal justice more broadly. And I think one thing that might be a takeaway from the comments that have been made in this panel is I think the language and the skill set for thinking about policing today is changing. Of course, traditionally you think about policing, you think about constitutional criminal procedures, you might think a bit about state laws and things of that nature. But I think to be fully kind of aware of what's happening in policing today, you also need to know a bit about the world of the private sector, right? Because realistically, thinking about policing today is learning about how to read a contract that a police department might have with a private company. What are the terms of their license with their data storage company or their body camera license? It's knowing a bit about the terminology of, AI and algorithmic accountability and what that means, and translating that, whether it might be before an audience, before in court, whatever those are. And I think that's really a big challenge today, to think more broadly about what it means to seek justice and transparency and accountability in policing. So having familiarity with some of these tools that seem a little bit out of the traditional box, I think is one thing that's increasingly important today.
Given what so many of our panelists have said about the relationship between the private sector and law enforcement, the ability to ask for and receive from private companies data about individuals, or the ability to buy that data and get an end run around other legal restrictions, I guess I would be interested if any of the panelists have any information about creative ways in which they're seeing regulatory law or statutory law or practices emerging to try and address that particular problem, which seems pretty important.
I can say a couple of things. So there are ways in which this problem of law enforcement access to our sensitive digital information is tied to, as you were suggesting, what companies are collecting in the first place. And so I think that some of the efforts to enact strong, what are often called consumer privacy laws, but really our privacy vis-a-vis corporate entities can be important in trying to give people the right to actually withhold consent from a company to collect and do stuff with their information. And the less information that is sitting on the servers of umpteen companies out there, the less law enforcement can get access to, either by sending a warrant or a subpoena or by signing a contract. And so that can be important. California has taken some important steps in that direction with a couple of recent laws. They're not perfect. There's a lot more that could be done. The tech companies in this area are working very hard to try to get Congress to pass federal legislation, because what they want is weak federal privacy legislation that preempts state laws and doesn't have a private right of action. And so that's something that I think is, it's important for our privacy against companies, but it also is important for what law enforcement can get access to. There are also legislative attempts, some of them really promising, if they can actually pass, to directly target what law enforcement is getting access to. Senator Wyden, along with a bunch of other members of Congress, has introduced a bill called the Fourth Amendment is Not for Sale Act to try to prevent police, law enforcement agencies at the federal level and those that receive federal funds at the state and local level from buying access to that app-derived cell phone location data I talked about earlier, from doing an end run around the warrant requirement they would normally have to do. Now, that would be a really significant protection if Congress could pass anything. As Catherine suggested, that's a tall order these days. Do I think it's realistic that Congress will enact that in this Congress? Probably not. They're not getting much done. So it's good it's out there, but it's a limited tool.
So there are a couple of questions we have from participants. This one probably is for you, Professor Joe, because it's about the Santa Cruz experiment that you mentioned. There's a question about whether the system, what the data is showing, or what system actors are saying in Santa Cruz about the impact on crime rates or crime before and after their decisions to use predictive policing and then ban predictive policing. Has it had any effects, salutary or derogatory, right, on the way in which the department there has operated?
So I don't know if they may, and perhaps some of my co-panelists know the answer to this. I don't know the specifics on Santa Cruz about crime rates. I know that part of the predictive policing ban in Santa Cruz was premised on the concern of racial bias. And I know that in general, the results on these predictive policing programs for sort of geographic predictive policing have been sort of mixed, at best. And then more broadly, thinking about predictive programs all around the place, we're starting to see raising of concerns, not just from activists and scholars, but even through third-party audits with inspector generals, like the LAPD is a good recent example, about efficacy in general. And I think one of the things here is, these programs are about how they're designed, but also most importantly, how they're implemented. And now that we're beginning to have historical experience with them, their implementation is often pretty problematic as well.
Okay. There's also a question I will open up to whoever would like to weigh in about to what degree we can take inspiration from data privacy laws in other countries, like the EU's right to forget. Has the legislation or the policies in other countries affected your research and advocacy? Do you think there's anything that can be learned from other countries' experiences here?
I can just jump in quickly. I know that the EU has a draft policy on AI, and it looks like it will be enacted at some time in the very near future. But one of the things that might be helpful there is that they are framing AI in terms of the level of risk posed, and that's been helpful, I think, in framing things in the EU, at least when it comes to kind of indiscriminate facial recognition technology use, for example. That's considered a very high risk use of AI.
Great. Thank you so much. Well, I see we are at 1 o'clock, so I feel like we could continue this conversation and go down a lot of different paths to explore it more. I hope for many of you who have attended this panel that this will be the beginning of your engagement with a lot of these subjects, and that you will continue to think about the different ways in which legal regimes or organization and community organizing and legislative and judicial interventions, regulatory approaches can all affect the way in which police access to and use of surveillance technology going forward occurs. And I want to thank all 4 of our esteemed panelists for their remarks and their thoughts and their insights on this subject today. So please join me in virtually, right, thanking them. They can't see you, but I can do this and they can pretend like it's all of you.
Thank you guys so much for attending our panel, and for anyone still on the Zoom call and everyone in the classroom, I just want to let everyone know that tomorrow we will be discussing surveillance and protest movements. So feel free to join us for that if you can. And just thank you again to our panelists and our moderator, Professor Primus. We really appreciate it. It was a great discussion. So have a great day, everyone. Thank you for joining.